Mr. Speaker, I have an amendment at the desk.
The gentleman has been recognized for 5 minutes.
The gentleman's been recognized for 5 minutes.
All right, Mr. Speaker, then I yield to myself such time as I may consume. As I said earlier, when considering any legislation, the House should first determine whether legislation is needed, and next whether the bill under consideration will adequately address or improve the situation. Before H.R. 2062 was brought to the House floor, the Committee on Education and Labor did not have a standalone hearing on the bill and instead held a subcommittee-level hearing on multiple wide-ranging topics. This complex and sweeping legislation deserves a further examination by the committee so members can gather more information from a variety of experts to make an informed decision regarding its practicality. Supporters of H.R. 2062 claim the Supreme Court's 2009 decision in the Gross case and 2013 decision in the Nassar case have harmed workers who have faced age discrimination or unlawful retaliation for claiming discrimination. Publicly available data does not show that the Supreme Court decisions in the Gross or Nassar cases have discouraged individuals from filing EEOC charges. A Democrat-invited witness who testified acknowledged that it is difficult to quantify the impact that the Gross decision has had on the number of older workers who bring cases and the number of those who win them. This witness also acknowledged that when we might have expected a drop in charges due to Gross-inspired discouragement from employment attorneys, there was a sizable jump in the number of ADEA charges filed with EEOC. In addition, a review of the Equal Employment Opportunity Commission, or EEOC, data shows that as a percentage of all charges filed, the rate of EEOC age discrimination charges is approximately the same as 11 years before the Gross decision, with a slightly higher percentage of age discrimination charges filed after the Gross decision. As a percentage of all charges filed in the 7 years following the Nassar decision, there's also been an increase in Title VII retaliation charges, which shows that individuals have not been discouraged from filing these charges. Further, a review of court decisions shows that plaintiffs have continued to win age discrimination and Title VII retaliation cases in the wake of the Supreme Court's decisions of Gross and Nassar. Bottom line, we must ensure that before we continue to legislate on an issue that may not need additional Washington interference, we have accurate data. My amendment simply states that H.R. 2062 goes into effect. Before H.R. 2062 goes into effect, the Government Accountability Office must conduct a study and report to Congress on whether individuals have been discouraged from filing age discrimination or Title VII retaliation charges and from filing lawsuits following the decisions in Gross and Nassar, and whether there have been fewer plaintiffs winning age discrimination and Title VII retaliation lawsuits. If the GAO finds that the individuals have not been discouraged from filing charges and lawsuits and have in fact won more lawsuits than prior to the Supreme Court decisions, then the bill will not go into effect. Let's not put the cart before the horse. I urge my colleagues to vote in favor of my amendment to ensure this legislation is actually needed and adequately addresses the purported concerns of the bill's sponsors. With that, Mr. Speaker, I yield back.